Thank you. Today we are debating the anti-corruption bill, and one of the big flaws of this bill is that it hasn't really given full effect to the United Nations Convention on Corruption. And that's a big flaw. It refers to certain provisions but doesn't give full impact to it. Dilumi Dialvis, the attorney at law, made submissions in the court about this, and I am really mentioning some of those. As we know, Article 156 was brought in the 19th Amendment. It was taken out in the 20th Amendment and brought back in the 21st Amendment. And in that, in Article 156, it clearly says measures to implement the United Nations Convention Against Corruption and any other international convention relating to the prevention of corruption to which Sri Lanka is a party. So, this is basically, we have committed to doing this, but we haven't really brought this into our law. We all know that Sri Lanka is a dualist state, so we sign up international conventions, but subsequently we have to give effect to it basically by bringing in local enabling law. Now, what we have done is we have actually not given effect to the United Nations Convention on Corruption, neither are we satisfying the constitutional requirement that actually is there. In the United Nations Convention, in Article 71, it covers 5 main areas: preventive measures, criminalization and law enforcement, international cooperation, asset recovery, and technical assistance and information exchange. So, in terms of the prevention, it covers legislation and measures every state should adopt and implement to enhance transparency, oversight, and control. On criminalization and enforcement, it identifies the main corrupt-related crimes, offences including bribery, embezzlement, influence peddling, work-related exploitation, illicit enrichment, and other crimes, and their sanctions. There's a reference to sexual favors being included, but not sexual bribery, and we agree with the members of the government who have also made the point that it should be actually sexual bribery that should be included. So if I were to say it in another way, the measures that are provided for in the United Nations Convention are aimed at finally tracing and retrieving stolen assets, especially the assets that are most often parked away in other jurisdictions. You see, in asset recovery, in Article 51, it says the return of assets pursuant to this chapter is a fundamental principle of the Convention, and state parties shall afford one another the widest measure of cooperation assistance in this regard. Our bill that is being presented today in Parliament does not talk about stolen assets recovery. And this is one of the main things that the United Nations Convention on Corruption talks about, but it doesn't provide for it. And the widest cooperation should be provided. It should be noted that in the proposed bill, the provisions had not been made to give effect to Chapter 4 and 5 of the United Nations Convention. Mutual legal assistance, transfer of criminal proceedings, none of this is in the present bill. Law enforcement cooperation, joint investigations, prevention and detection of transfers of proceeds of crime, measures of direct recovery of property, mechanism for recovery of property through international cooperation in confiscation, international cooperation for the purposes of confiscation, return and disposal of assets, financial intelligence, none of this is there. It is also pertinent to note that the statement set out in Article 1 in the Convention on International Cooperation is talking about asset recovery as one of its main purposes. And this anti-corruption bill ignores it, and that is not acceptable. Therefore, we must say this: not only are we not fulfilling the obligations of the United Nations Convention, which we signed in 2004, we are also not meeting the constitutional requirement that is stated in our own constitution. Therefore, it is cast upon the states, especially in view of the reintroduction of Article 156A to the Constitution, to bring sufficient measures to the proposed new law for the implementation of the United Nations Convention. We haven't done this. Then we go to London in 2015. We had the London Anti-Corruption Summit, Not only in 2004 did we sign the United Nations Convention on Anti-Corruption, we go to the Global Forum on Asset Recovery in December 2017. And Sri Lanka is one of the 4 focused countries, right, along with Nigeria, Ukraine and Tunisia. And we commit to it, but we don't do anything about it. This is a law we are bringing after 30 years, and still we are not doing it. We are hiding behind the fact that we have some laws, like the Money Laundering Law of 2006, Financial Transactions Reporting Act of 2006, Mutual Legal Assistance and Criminal Matters Act of 2002. But these are not sufficient. We should have included a more comprehensive measures in this law. Several practical issues faced in prosecuting money laundering, now this is in practice what has happened, has made it nearly impossible to successfully complete prosecutions under the present Act. Therefore, reliance cannot be placed on the provisions of the Money Laundering Act for asset recovery. So we have really failed on the fundamental principles, and therefore we must do something about it, even through the amendments. I might also say that Transparency International under Krishanta Valyamuna in the past, Asoka Ubesekara, and now the present head of it being Nadishani Pereira, all attorneys at law, have done a tremendous amount of work over a long period of time to actually make asset recovery an important part and anti-corruption. Silencing informers and whistleblowers is another issue. On Article 119 in the present law proposed, it's talking about giving them 10 years if they have informed under malicious intent. I think we need to relook that because I think you are going to silence whistleblowers if you do that. And then there's also the withdrawal of indictments in Article 67, which needs to be looked at. We know that the Aegis Department has been putting prosecutions, withdrawing it. Sri Lanka has a very poor track record. And are we going on the same route? Therefore, we should relook at Article 67, if necessary, even delete Article 67. So I would say this, the ultimate test is, who have we brought to justice? 2, what are the assets that we have recovered? 3, has corruption actually reduced? Mama සඳහන් කරන්න ඕනේ පුද්ගලික මන්ත්‍රීවරයෙක් හැටියට මම යෝජනා ඉදිරිපත් කළා වැත්කම් බැරක්‍රම් ප්‍රසිද්ධ කළ යුතුයි කියලා කියලා තියෙනවා. ඒ වගේම එකතු කළ අගය VAT එකත් ගැනත් මම පුද්ගලික මන්ත්‍රී යෝජනාවක් ඉදිරිපත් කළා. එතන මුදල් ඇමතිතුමාට ඔක්කොම වාලේ තියෙනවා. යට ඕන විදියට මේව කරන්න. ඒවා පාර්ලිමේන්තුවට ගේන්න ඕනේ කියලා. ඇයි මේව කරලා තියෙන්නේ මේ පුද්ගලික මන්ත්‍රී යෝජනාවල්? මේවා ඉදිරිපත් කරලා තියෙන්නේ එක හේතුවකටයි අල්ලස දූෂණය ආම කරන්න. අපේ වත්කම් ආරක්ෂා කරන්න නෙමෙයි පුරවැසියාගේ වත්කම් ආරක්ෂා කරන්නටයි. ඉතින් මම අහන ප්‍රශ්නේ මේකයි අන්තිමට. නීති ගේන්න පුළුවන්. නීති අඩුපාඩු නෑ මේ ලංකාවේ නීති ගේන්න පුළුවන්. ඇත්තටම හොරු අල්ලනවද කියන එක තමයි මට අහන්න තියෙන ප්‍රශ්නය. හොරු අල්ලනවද කියන එක.
ඔබතුමාගේ කාලය අවසానයි කරුමන්තුමා.
ඉතින් මම නැවතත් කියනවා මේක නීතිය ගෙනල්ලා විතරක් මේක කරන්න බෑ. ස්වාධීන නඩු පැවරීමේ කාර්යාලයකුත් අවශ්‍යයි. මේකට ජනතාව නීතිය ගෙනාවා කියලා මුලා වෙන්න එපා. ජනතාව හොරු අල්ලනකම් රජය පිටිපස්සේ යා යුතුයි. මට ලබා දුන්න කාලය ගැන ස්තුතිවන්ත වෙනවා.
ස්තුති මිලන් ගරු